You're not going to get it from him. You're not going to get it from the next assigned counsel or the next one or the next one or the next one or the next one. If you had that many opportunities.
Good morning, my Andrew.
All right.
Today is the date and time set for a pretrial. I had an opportunity to speak with Mr. Deal on our initial intake screening and assessment. We did have a structured meeting attempt this morning. It did not go well. I do apologize. There has been a complete breakdown in the relationship. I do not want to air out dirty laundry with my client and I in the court system.
Okay, listen, this is the second lawyer. We're not doing this.
I'm thinking third time's a charm. Judge, I
Nope.
less than 3 minutes. So
I'll let him out, but you're going to do something by yourself, sir. You can't get along with any lawyer. That's a problem. You could go out and hire your own and you won't get along with them. You know why? Because you don't want to hear what they got to say. They're giving you their professional assessment, whatever it is.
it's the tail wagging the dog is what I felt in the office.
Yeah.
That's all I'm saying.
And we just went through this. You got a totally different person, didn't know what the case was about, got the discovery, looked over it, met with you, tried to tell you something, and then you went the total other direction and going to tell them what to do or what you thought they should be doing. Now, these people are trained. They have to go to school for this. They have to learn it. Then they have to come out and practice it and do it. And these people have been doing this he's been doing way more than your other lawyer, Mr. Shreeman. I've been doing this for 40 years. Quite frankly, I don't know what's going to satisfy you, but perhaps you should represent yourself because you're never going to get a lawyer, apparently, that you're going to agree with. So either you're going to keep him and deal with him or not. That's it. So what do you want to do?
I'd like to keep them.
Okay, good. So why is there a breakdown without going into the specifics? Is it that he's telling you stuff you don't like and you want to tell him what to do? Well, then you tell me generally. You have to go to the specifics. Why is he in here trying to withdraw? And this is basically his first appearance since we released the other lawyer.
I've only withdrawn twice with clients in the history of being in front of you, Judge. I'm not going I already know based on experience, there's personality. I couldn't even take notes. So
You couldn't take notes.
I couldn't take notes. Yeah. I don't want to air out my dirty laundry with my client.
Go ahead, sir. Go ahead.
I was trying to set a foundation by writing things out. He didn't like it. I closed this up, asked him exactly what you said. You are absolutely correct. That is exactly, that is.
Let him talk. Let him talk. Let him talk.
That is exactly what you said is exactly what happened in that room. There's now a personality issue going on, a conflict. I don't want to represent him.
He's trying to take notes and you didn't like that?
You like me to answer, Brian?
Obviously, if I'm addressing you.
So, when I first talked to him, he said, let's meet and see how you want to approach this. Okay? He told me he was going to call me. He didn't call me. Then he told me he was going to send me the discovery package by email. He never sent it.
There's a we scheduled a meeting to be here early so that we could go over it together in person.
That didn't happen, Your Honor.
He was late. He was over 30 minutes late.
Your Honor, he never sent me a text or an email to schedule no meeting. If you did, have him show it.
No, meeting here today.
How was I supposed to know? You didn't send it to me.
That's what we
Who did you
spoke.
send it to?
That's my
Did you
position.
leave me a voicemail?
Okay, sir, we're not having all that.
You didn't send it.
Okay, perhaps you didn't get it. I don't know.
You can't even show me where you sent it.
Okay, so what? We're here.
He made it seem like I'm being hustled out too. When he didn't receive the text, man.
Okay, can we get past this, please?
I would hope so, Your Honor.
Now, you didn't get it for whatever reason. He was here expecting you. You didn't get it. Okay, I get that. So why is it once he did get here and you got here and he sat down, you got a problem with him taking notes?
He said you either go to trial and take a copy.
But that's the options.
He asked me what I'd like to do. I said, I would like to examine a forensic examination of the phones.
Oh, yeah, that's the same issue you had with the other guy.
You know, where we-
Sir, let me tell you something. I believe Mr. Shreeman looked into this issue for you. These are appointed counsel, okay? Because you're not paying. You get your own lawyer, you pay. Guess what you have to do? You have to pay to get a forensic expert to examine the phones. You could do that on your own dime. They have to go to the Indigent Defense Commission, and they do have resources for experts. But they have to tell them what kind of expert and why. The bottom line is the Indigent Defense Commission will not give you an expert to examine a phone. That was the ruling. So you can't get it. You're not going to get it from him. You're not going to get it from the next assigned counsel or the next one or the next one or the next one or the next one. If you had that many opportunities. The only way you're going to get that is to fund it yourself. So if you would like to hire your own forensic expert to go through a phone, that's not a problem. You should do that. You should let your lawyer know who it is so that they can talk to them and find out what the report's going to be and turn over any evidence of that to the prosecutors so they can look at it.
I thought the prosecution supposed to do that.
No, it's your evidence.
I thought they had to prove me guilty, not me prove myself innocent.
I didn't ask you what was the burden of proof. I said turn over discovery. There's a rule on that.
If he happened to get discovery, nobody showed me the discovery.
I'd be more than happy to share my paper copy of the discovery with him. But moreover, I'll email it to him today. I'll email it to him in the courtroom.
Okay, where is it?
I have it right here.
Sir,
I don't have it. Good.
sir, listen to me. You were 2 seconds away from getting me to hold you in contempt. You are combative for no reason. Where is it? Where is it?
I'm sorry.
The man said he was going to give it to you. All you need to do is stand there and wait. We don't need you to be hyping the whole situation up by telling him, where is it? Where is it? Like you're about to attack somebody.
Okay,
I didn't know. Listen. You got a lot of mouth for no good reason.
well, I'm just not getting this.
Sir, so what? You got it now. And if you needed time to review that with your lawyer, I would give that to you. So you're no worse off. So what's your beef now?
Well, now that I have it, now I can look at it myself.
But this forensic expert thing is not happening. Do you understand that?
Yeah, I understand.
So now, what's the problem with the lawyer taking notes? I'm back to that.
The first thing he said to me was, take a copy. And I asked him for the information. He said, he sent it to me. And I said, I don't have it. I asked him, what was the information? He
Okay.
didn't say.
So what's that got to do with him taking notes?
He asked me what I wanted him to do after that. And I told him the forensic thing. He said, I quit.
Okay. So now we know that's not happening. Now you need to figure out how you want to proceed with the discovery you now have.
Well, I just got it today.
Okay. Okay. And let me tell you something. I'm not releasing you. Nope, not going to do it. But what I am going to tell you this.
No, it's not even.
Stop. What is wrong with the discovery?
Guys, it's not the right before.
It says Dwayne Deal right there.
Yeah, I know, but what does it say right here? It's talking about alcohol and domestic violence. That's not breaking into. It's not mine.
Judge, I have an electronic copy right here. My computer is on. If there's an issue with the discovery, I'll take care of it right now. As the court knows, I photocopy both sides. I've given you, as I say, paper. I'll just send him an electronic copy. I have his email and I'll send it in less than 5 seconds.
Okay. Good.
Opinion, then I have a chance to.
Mr. Deal, stop talking to him. Talk directly to me. Okay.
It's not. I save paper. I
Sure,
copy
sure,
both sides.
Would you like to just see?
I've given it to her before while I told her.
That's a whole different case.
Your name was on there. Sorry.
I got two cases.
Sir, this is what I'm talking about. I asked you to stop arguing with him. You're arguing. You can talk to me and tell me that you think that was the wrong discovery. He said if it was, he'll go email you the correct one. He says that he double sides to save paper. So I don't know if you're getting part of someone else's case on the backside. It could be. I don't know. But your name was on there. So you need to stop arguing so much and being so combative with people and just calm yourself down and look at what you're given thoroughly before you start fighting about it. You're so hostile. You don't have to be. Nobody is going to do anything with you till you adequately review the discovery with the counsel. But you can't. There's no way you can have a good relationship with any lawyer acting like that. Nobody wants to be hollered at like that, made demands of like that. It's horrible. You could ask the same thing in a different way and it would be okay. Your approach is bad. Do you see what I'm saying? Your approach is just not good. All you need to do is say, hey, thanks for the discovery, but I don't think this is the right one. I don't see my name on this or whatever. You're up there talking about, this is not mine. I told you, I didn't get this. No, that is hostile. Who would want to work with you like that? It's not what you're saying. It's how you say it that makes a difference in whether your relationship with any lawyer is going to break down. If you understand what I'm saying.
Yeah.
So, you just need to start before you open your mouth. Count to 10. Take a breath and say, okay. And then say what you need to say. That'll calm you a little bit.
Explain. And the attorney that he's arguing.
You have anxiety. Okay, I understand that. That's understandable. People do.
Have a meeting somewhere else, maybe like it's just off somewhere, not seeing a bunch of police and stuff walk around in a little bit more calm, environment.
Okay,
Hands on.
that's fair.
It's not happening. Wait till get 5 minutes before we get here and then start shoving stuff down my throat. And I don't understand what's going on. Yet I ask you for the paperwork and you tell me you sent it to me. And I say you didn't. And then you can't find the judge, make it seem like I'm a bad guy. Give me the
You're not a bad guy. Nobody thinks.
I'm going to give up saying.
We want you to just calm the anxiety part down. That's all. No one is saying you're a bad guy. I don't think you're a bad guy. I said your approach is bad, and now I think I understand why. You do seem to suffer, as you said, from some level of anxiety about the process. So you got to take that in mind now, Mr. Baldwin. He has a little issue there.
Your Honor, I would be more than happy to do a reset with my client.
Okay.
Perhaps maybe what we can do is reschedule this.
Yes.
There's a library in the parking lot right over here.
You want to go to the library today?
Well, I have to be in front of.
Okay. Well, you want to meet him at the library, maybe?
More importantly, I'll email him the discovery before I leave. My computer is on here in the courtroom.
Okay.
I have
Did you have a cell phone? Did one?
Pictures and videos, you can't transfer it. You can't, transport or transfer that type of material.
Well, the video file is usually a link that he gets from the prosecutor, which he could open. So go ahead, prosecutor.
Given the nature of the video, Your Honor,
It's illicit.
we can't send it out.
Oh,
Previous defense counsel came to my office and reviewed it. Mr. Deal declined to come with his attorney to view that material.
That's not true.
Mr. Baldwin is welcome to come and view that at his convenience at our office.
okay, sir.
I'm
Listen.
not sure she knows, but you said that I could be present.
Yeah.
They didn't do arrange it for Dwayne to be present. They did it without me.
Okay. Okay. So this is what we're going to do. He's going to email you this. He could meet you at the library, go over everything except for the video. Then you two will make an appointment time that's suitable for you both to go up to their offices in Pontiac to see what the video shows.
That works, Judge. And if we can schedule a court date,
And I want you to breathe.
we'll come to the
Yes.
library before the court time so that we're all.
Yeah, a different day. Not even do it on the court
That's
day.
fine, Judge.
Do it ahead of time.
I can schedule that behind me.
Yeah.
We can meet here at the public library. I have a laptop. I can move large amounts of information, whatever it needs to be done.
And then
I
you'll,
just need an opportunity to communicate with the client, and I'm not giving that.
okay. And over there, so sir, I'm telling you, when you go to the meeting, you need to breathe and calm down. And don't be accused. Just say what you want to say without accusing somebody of X, Y, and Z. Okay? You can tell him what your position is on it without getting upset. Let him write it down. If he tells you his opinion, you can say, oh, I disagree with that. Or why do you think that? Without getting hostile because he has a different opinion than you. You see what I'm saying? That's how lawyers and clients work through things. Because he might have a different opinion based upon his knowledge of knowledge of the law or something else. And that's why he's telling you something. Okay? But you got to start thinking and breathing and count to 10. Listen, I get upset sometimes. I do that. That way I don't just blurt something crazy out. Everybody should be doing that kind of thing. And it will help ease your anxiety. And you can't get loud in the meeting rooms in the library anyway, okay? You just can't. All right. So that's what we're going to do. You two will then get a date and arrange it with the prosecutor's office to watch the video. Then you can talk about whatever you need to talk about with him after the video too. So you have 2 times to talk, at least. One at the library and then one after you watch the video.
Watch the video on Pontiac.
You have to because they can't send it out because of the nature.
And I'll coordinate all that, Your Honor. If we can get another court date, first of all, I look forward to working with you. You have my business card. If we can get another court date,
Yeah.
move this along.
Okay, next date.
Thank you for.
Court's available January 28th at 9:30.
Yes. And I want you to be part of that right now.
Court's available January 28th at 9:30.
Is that good for both?
No, not for me, Jim.
Okay.
I know.
Court's available February 2nd, 9:30.
That's Groundhog Day, but I'll take it.
Hmm.
February 2nd, is that good?
I don't
think
know.
We can get through this by.
Is he supposed to see his shadow and we have a long winter? Or if he doesn't see his shadow?
What time, 9:30?
9:30.
We doesn't see it.
Yes. And we can do a step in order if necessary, if we're moving along
Mm-hmm.
with more time. And I will work in conjunction with my client and we will move this case forward. And I thank the court for its assistance.
Okay, so the bond is continued. February 2nd, 2026 at 9:30 is the adjourned pre-trial date. Okay,
Thanks, Judge. May I have just one moment to speak with Mr. Baldwin before we vote this?
sure.
What we're going to do.
And I do have Miss Curtsey, if that's all with you. I'm all set. I'll give you a call on,